Excellences, distingués délégués, c'est un honneur et un plaisir renouvelé pour moi de déclarer officiellement ouvert la 6e séance plénière de la 24e session de l'Assemblée de cet parti consacrée à la non-coopération et de vous souhaiter à tous la bienvenue. L'Assemblée, lors de sa 23e session, a décidé de renforcer son engagement sur cette question fondamentale. La séance aujourd'hui constitue une étape concrète en ce sens. Nous espérons que ce format pourra servir de plateforme de dialogue prospectif axé sur la recherche de solutions pour apporter des questions relatives à la non-coopération soulevées durant l'intersession. Comme il s'agit de la première fois que ce point est inscrit à l'ordre du jour de nos débats en séance plénière, je souhaite que ce format puisse être perfectionné et devenir une utile dynamique à la Cour et aux États parties. Cette innovation dans notre travail prend la forme d'une table ronde qui explorera une série de questions identifiées, puis sera suivie d'interventions de participants de 3 minutes maximum. Dear colleagues, dear delegates, our focus today is on prevention. We seek to deepen our understanding of the tools available to prevent instances of non-compliance. In this regard, I wish to underscore the importance of Article 97 of the Rome Statute, which obliges states parties to engage in timely consultations with the court whenever problems which may impede or prevent the execution of a cooperation request arise. This obligation is not only legal but also practical. Timely consultations can help resolve challenges, clarify misunderstandings, and ultimately ensure that the court is able to fulfill its mandate and that judicial decisions are carried out. The founders of the Rome Statute did not define in detail how the consultations under Article 97 should begin or unfold. This has mainly developed in practice and through assembly deliberations. At its 16th session in 2017, the Assembly adopted the understanding with respect to Article 97C. The understanding seeks to clarify the process for consultations between the state party in certain cases. We will also discuss other concrete mechanisms available to prevent and address non-cooperation, namely the Assembly procedures relating to non-cooperation and the toolkit for the implementation of the informal dimension of the Assembly procedures. The panel will also explore how different stakeholders can use the procedures and the toolkit to promote cooperation with the court. Interesting questions have been identified to be explored by the panel, and I'm myself very much looking forward to this discussion. I would now give floor to the first panel member, Antonia Pereira de Sousa, Chief of Office to the Registrar. You have the floor.
Many thanks, Madam President, Excellencies, esteemed colleagues. It is an honor for me to address you today, and I would first like to thank the President of the Assembly of States Parties for convening this important plenary session on non-cooperation. To frame my intervention today, I will first briefly introduce the role of the registry in the context of judicial cooperation. As you're well aware, the registry is the neutral organ of the court and is not a party to the judicial proceedings. It provides services to all parties and participants so that the ICC can conduct fair and effective public proceedings. We are also the main channel of communication with ICC states parties when it comes to these judicial proceedings. This neutral role enables the registry to facilitate dialogue and consultations between ICC states parties and the court as a whole, such as, for example, by advising states on all matters related to judicial proceedings or transmitting requests for cooperation on behalf of the chambers. Ultimately, we are the officers of your court. To effectively obtain cooperation, the registry has adopted a strategic multi-pronged approach, ranging from, first of all, initial working level contacts wherever possible from the registry's Judicial Cooperation Support Section, the chief of which is sitting behind me today, in advance of transmission of cooperation requests, to discuss the objectives of these requests and ensure adherence to the ICC applicable norms and to national requirements. Second of all, actual request transmission and timely follow-up to assist and ensure smooth execution. And thirdly, continuous availability of staff of the Judicial Cooperation Section and the Registry to consult with states on any impediments and issues that may arise in order to resolve them without delay. In this context, the Judicial Cooperation Section team also frequently takes the opportunity after execution of these requests to engage in lesson learned exercises and good practice follow-up with national authorities to ensure that we can learn from our common experience and also that we can continuously seek to identify ways to improve our processes and to find efficiencies moving forward. As is evident, this approach to cooperation allows both the court and the state party in question to discuss any concern or challenges that may arise in the process of the court requesting cooperation, and to do so in advance in order to promote the identification of solutions and to prevent any instance where the cooperation request cannot be fulfilled. As you know, pursuant to Part 9 of the statute, at any given time, states parties have the possibility and are actually strongly encouraged to initiate consultations with the court. The scope of these consultations is foreseen and encouraged throughout the Rome Statute and appears across multiple provisions, including but not limited to Article 97, where it is set the most clearly. The understanding with respect to Articles 97C consultations, which Madam President referred to before, was adopted through an ASP resolution in 2017 and emphasizes, and I quote, the importance of procedures and mechanisms enabling states parties to cooperate with the court, particularly when a state party receives a request under Part 9 of the Rome Statute in relation to which it identifies problems which may impede or prevent the execution of the request. End of quote. So the understandings document make clear that neither the request for consultations nor their outcome automatically suspends the execution of the court's cooperation request, unless, of course, a competent chamber explicitly orders otherwise. Also, these understandings foresees that such requests for consultation, where they relate to a cooperation request originating from a chamber of the court, should be transmitted through the registry. As I mentioned, the objective of such consultations is to promote successful cooperation and prevent non-compliance by states parties with their cooperation obligations without delay. As you're aware, subparagraphs of Article 97 contain a non-exhaustive list of types of difficulties that may arise requiring consultation with the court, such as insufficient information to execute the request, or the fact that the execution of the request in its current form would require the requested state to breach a pre-existing treaty obligation undertaken with respect to another state. Such consultations may relate to both requests for arrest and surrender, as well as to other types of requests for cooperation, such as taking or production of evidence, the service of documents, the execution of search and seizure requests, or financial requests related to the identification, the tracing, and the freezing and seizure of assets. The registry and our judicial cooperation team stand ready to facilitate this process of consultation and dialogue, which may be undertaken at the working or technical level or may be addressed to the relevant chamber of the court, for example, where they relate to a matter that bears on the substantive legal or factual merits of the cooperation request. Again, the goal is always to foster dialogue and to resolve any challenges arising from a particular request for cooperation. Let us consider what guidelines has the jurisprudence of the court set in relation to this process, which I think is relevant also for this conversation. From the perspective of the court, cooperation is as much about the process than it is about the result. In terms of the jurisprudence, the chambers have recalled that for consultations to be meaningful, they must be timely. In another decision where the chambers noted that the court's effort to engage in consultations with a state party, it drew attention to the opportunity of the requested state to engage and consult with the court, or at the very least, to inform the court of any obstacle to comply with the request. And in another decision, the chambers emphasized the need for states parties to act with due diligence and to use all reasonable measures at its disposal to comply with the request for cooperation. Now, before concluding, as I know we have a number of very important panelists coming after me and interventions planned, I would like to highlight that the registry continuously looks for ways to deepen its relations with states parties to foster a conducive environment for cooperation. This year, we have had engagements with a significant number of ICC states parties, both in person and remotely, and we are eager to build on these in the coming year. These engagements have ranged from submitting requests for arrest and surrender or provisional arrest, requests for cooperation on the identification and whereabouts of suspects, initiating discussions with ministries of justice and foreign affairs on national procedures in place to execute the registry's requests for arrest, or collaborating with operational counterparts at the national level to engage in joint tracking activities or learning exercises. I would, to conclude, like to utilize this opportunity to thank our ICC states parties for engaging in such constructive exchanges with the registry and encourage you to also provide feedback to the court on how to engage more effectively with your designated cooperation channels. We look forward to continuing these exchanges, and we remain available and eager to work together with you to create a cooperation environment that fosters effective engagement and collaboration. Thank you very much, Madam President.
Thank you very much, Antoni Pereira de Sousa, for your interesting, timely intervention and explaining how this all looks from the perspective of the registry. And I would now invite Jonathan Agar, Head of the External Affairs of the Office of the Prosecutor, to share his perspective. You have the floor.
Thank you so much, Madam President. And thank you, colleagues, for your engagement and support during this Assembly of States Parties. It's very much appreciated by the Office of the Prosecutor. And my name is Jonathan Agar. I'm head of the External Affairs Unit in the Office of the Prosecutor. One of our functions is to support the judicial cooperation with you, states parties, across the office. As many of you know, the cooperation function within the OTP is largely integrated into the unified teams who are responsible for taking forward the work in relation to specific situations. But the External Affairs Unit seeks to make your lives easier as states parties by ensuring we're doing so coherently and as effectively as possible. And in addressing this topic, if I may begin with a slightly positive message, in fact, by noting that in that experience of working with states parties, we have a very positive landscape of engagement with states in terms of responses to our requests for assistance. And we are grateful for that and the support provided by really all states that we engage with in support of our investigations and prosecutions. We had, in fact, an example of that very positive cooperation within the courtroom of the ICC today, as a result of the cooperation of German authorities, so our thanks in particular for that. But of course there are examples of non-cooperation and important examples that mean that this session is of particular importance. It is of course an innovation in practice and it is one that the Office of the Prosecutor welcomes given the importance of dialogue with states in relation to this issue. Our hope is that this discussion can assist in underlining the value of communication between the court and states so that we can collectively reinforce the Rome Statute system by ensuring better adherence to its provisions, particularly with respect to the arrest of individuals subject to warrants issued by the ICC. We welcome in particular the emphasis placed in the concept note, and I'd imagine also in our discussions, on the importance of consultations pursuant to Article 97 of the Rome Statute. We wish to underline from the Office of the Prosecutor the value that we ascribe to this process, which should be considered by states as a tool that is available to states and a tool that's available to us from the side of the court to make sure that we can mitigate the risks of non-compliance. It should be considered a platform for dialogue, and states can work with the court to seek to avoid breaches of the statute. Indeed, of course, this is an article of the Rome Statute that was inserted by states seeking to provide this platform for engagement. Reflecting the importance attached to this process at the time of drafting, of course, it also represents a legal duty that must be fulfilled if a state is facing an issue in compliance with a cooperation request from the court, such as an arrest warrant. From the perspective of the office, the Article 97 consultations process is also of great value in understanding and obtaining information on the specific challenges that are being faced by a state. So we consider the Article 97 process a platform through which we as an office can understand from states what is the challenge that is being faced and potentially how can we address that together. In contrast, where the Article 97 consultation process is not used, this can mean a more proactive approach by the office, including with respect to before the pretrial chamber regarding alleged non-compliance. If the office lacks information, if we lack context, or we lack understanding as to the reasons for a state's non-compliance, this can give rise to greater concerns from the perspective of the office. A state's failure, therefore, to engage in the Article 97 process can also potentially be treated as a further breach, and in that context, the office may seek to engage more formally in order to obtain the information that we need to understand the position faced by the relevant state. Ultimately, the Article 97 consultations process is a strong force for strengthening dialogue that may reduce the possibility at a later stage of proceedings under Article 87(7). We therefore very much welcome this discussion, which we view as an important opportunity to discuss how we can reinforce the processes that are built into the Rome Statute, so as to strengthen our common action under this framework. It is essential, particularly in this moment, that we come together, that we maximize our common ground, and reduce areas of dispute or misunderstanding. That is why we encourage all states to engage proactively with the court when they have concerns over responses to requests for cooperation. If I may conclude with a further positive remark about, again, thanking states parties for all the good examples of cooperation that we've received during this year and previous years, and we look forward to the discussion. Thank you.
Thank you very much, Mr. Agar, for your informative and relevant statement. And we would then move on to remarks by representative of states, parties, and ACT country focal points on non-cooperation on this panel. And I now invite Anna Madrick, a representative of the ACT country focal points on non-cooperation, to share her views. You have the floor.
Thank you, Madam President. Excellencies, distinguished delegates, ladies and gentlemen, it's an honor to participate in this panel as a representative of the ACT country focal points on non-cooperation. My government, Vanuatu, as well as Mexico, Poland, Sierra Leone, and Finland. The ACT country focal points mandate is established under the Assembly Procedures of Non-Cooperation, pursuant to the Annex of ICC ASP/10/Res 5, in order to support the Assembly's President in the exercise of promoting full cooperation with the Court. Paragraph 4 of this resolution provides that, for the purpose of the relevant Assembly procedures, non-cooperation could be understood as the failure by a state party or a state which has entered into an ad hoc arrangement with the Court to comply with a specific court request for cooperation under Articles 89 and 93 of the statute, as defined in Articles 87, paragraphs 5b and 7 of the statute. The focal points mandate relates to preventing instances of non-cooperation before they occur. In this regard, on behalf of the focal points, I would like to emphasize that the Assembly's procedures relating to non-cooperation provide both formal and informal procedures to support states parties in meeting their cooperation obligations. As everyone present knows, the success of the International Criminal Court depends on states parties' cooperation. Therefore, a key component to success is states' independent enforcement of arrest warrants issued by the Court. Under Article 97 of the Rome Statute, states parties shall consult with the Court in potential or realized instances of non-cooperation. The pretrial chamber has previously affirmed that the fundamental objective of consultations under Article 97 of the statute is to resolve a problem that the concerned state party has identified, which may impede or prevent the execution of the request for cooperation. On this matter, the Rome Statute is clear. Article 87(7) of the statute reads, "Where a state party fails to comply with the request to cooperate by the court contrary to the provisions of this statute, thereby preventing the court from exercising its functions and powers under this statute, the court may make a finding to that effect and refer the matter to the Assembly of States Parties." In interpreting this provision, the Appeals Chamber has held that the first clause of Article 87(7) of the statute consists of two cumulative conditions, namely, that the state concerned failed to comply with the request to cooperate, and that this non-compliance is grave enough to prevent the court from exercising its functions and powers under the statute. It is only when the Chamber has established that both conditions are met that it may proceed to consider whether to refer the state to the Assembly of States Parties. As noted, there exist both formal and informal tracks available to states parties and other stakeholders working with the court to prevent and address instances of non-cooperation. These are outlined in the Assembly's procedures relating to non-cooperation. The formal procedure for the Assembly to address instances of non-cooperation is only triggered in one circumstance: a legal finding of non-cooperation and a subsequent decision by the court to refer the matter to this Assembly. In such a situation, there are a variety of measures available under the formal procedure, including the convening of an emergency bureau meeting, open letters from the Assembly President to the state party in question, invitation for the requested state to attend a meeting of the bureau, the convening of a public meeting with the requested state, noting the court's decision in the omnibus resolution, a bureau report on action taken and recommendations, or discussion in a plenary session. The bureau is also empowered to appoint a facilitator to consult on a draft resolution indicating concrete recommendations on the matter. In relation to informal procedures for non-cooperation, available for use in the instance of a potential instance of non-cooperation, the informal response procedure and the toolkit for its implementation provide comprehensive guidance on actions that can be undertaken by the Assembly President, the focal points, and states parties to respond. This includes request for arrest and surrender, in which urgent action may initiate cooperation in that specific case. The focal points assist the Assembly in the exercise of the President's good offices, thereby promoting legitimacy of the Rome Statute as a whole. The focal points highlight that in relation to such instances of impending or ongoing non-cooperation, these matters should be raised informally, yet directly, with officials from the requested state, as well as other relevant stakeholders, with a united view on promoting full cooperation. As appropriate, we highlight that states parties should also be encouraged to engage in relevant outreach. The toolkit includes pre-agreed templates and formulations for draft statements, note verbals, speaking points, media releases, and tweets in different scenarios. There are, inter alia, other provisions on monitoring the travel of persons subject to arrest warrants, and other aspects related to cooperation vis-à-vis Security Council referrals. We further highlight that civil society can, and does, play an important role in assisting states parties in the implementation of certain measures. The focal points on non-cooperation lastly emphasize that the Assembly's work in preventing and addressing instances of non-cooperation is in the interest of all states parties. We underscore that the ad-country focal points, as well as the Assembly procedures relating to non-cooperation, are available to support this critical objective of the Rome Statute. The scope and extent of the Assembly procedures, as well as of the mandate of the ad-country focal points, remains at the continuing discretion of this esteemed Assembly. Madam President, I shall briefly conclude in my national capacity. Vanuatu reiterates our significant concern at recent instances of non-cooperation with the ICC. We call upon all states parties to support the Rome Statute and the Court, including through important ongoing efforts to strengthen the statute in the face of evolving threats to international peace and security. The success of the ICC and the Rome Statute system depend upon our ongoing commitment to it, as well as our cooperation with it. Thank you for your attention.
Thank you. Thank you very much for your informative statement. And I would now give floor to the last speaker on our panel, Ms. Cristina Orsini from Lawyers for Justice in Libya. You have the floor.
Thank you. It's an honor to speak to you today on behalf of Lawyers for Justice in Libya. As we have heard, without cooperation, the court cannot function. This is why, as a civil society representative, I welcome that, for the first time, non-cooperation has a dedicated item on the ASP plenary agenda. This is an important step, but also a testament to a sobering reality. Non-cooperation remains one of the ICC's most entrenched challenges, including among state parties. This past year provides many illustrations of this. Despite an arrest warrant issued against Benjamin Netanyahu, he was able to visit Hungary, triggering a finding of non-compliance and Hungary's withdrawal from their own statute. Several states, including Germany, France, and Poland, have publicly expressed doubt that they would be ready to arrest him. Similarly, Vladimir Putin visited Tajikistan and Mongolia last year without being arrested despite a pending warrant. As an NGO representative of Lawyers for Justice in Libya, an international and Libyan NGO working for transformative justice in Libya, I'm speaking to you today because the Libya situation sadly offers many illustrations of non-cooperation and its very tangible impact. Libya is not a party to the Rome Statute. However, UN Security Council Resolution 1970 of 2011, which granted the court's jurisdiction in the Libyan situation, requires Libyan authorities to cooperate with the court. In May this year, the Libyan Government of National Unity also issued a declaration accepting ICC jurisdiction. However, restrictions imposed by authorities and security risk for victim witnesses and civil society have impeded effective investigation inside Libya. Libyan authorities also continue to consistently fail to arrest or transfer individuals subject to ICC arrest warrants to the court. In 2014, this already triggered the finding of non-cooperation from Pretrial Chamber 1 in relation to Libya's failure to arrest and surrender Saif Gaddafi, resulting in a referral to the UN Security Council, with very little consequences stemming from this referral. Another finding of non-compliance in relation to Libya was made by Pretrial Chamber 1 this October, this time against Italy, although the Chamber decided to wait to refer the case to the Assembly of State Party or the UN Security Council under Article 87.7. This story is illustrative of wider worrying trends. On 19 January 2025, Italy arrested Osama al-Masri Najim after the ICC had issued an arrest warrant against him on the previous day. A few days later, Italy, a founding member of the ICC, returned him to Libya as a free man. Italy cited domestic legal and procedural issues to justify its decision. On the contrary, it seems that the mix of political concerns and diplomatic pressures led to the subordination of international obligations and justice consideration to political expediency. Italy's failure to surrender al-Masri to the court is a breach of its international obligations. In the process, Italy also did not consult with the court, failing to respect the request for consultation set out in Article 97. As noted by the partially dissenting opinion of one of the judges, the Chamber's reluctance to refer Italy's non-compliance to the ASP or the UN Security Council sends the wrong message, that non-cooperation by state parties will be met with mild consequences, if any. Why does this matter? First, in a context in which the court, its officials, and civil society working for international justice are increasingly under attack, including through US sanctions, each instance of non-cooperation is a further blow to the Rome Statute system, and especially when it comes from state parties. Second, each instance of non-cooperation entrenches impunity and is a missed opportunity for justice. Had al-Masri been transferred to the ICC, his would have been the first trial to be opened in the Libya situation, after 15 years of investigations. Now, the first ICC case related to Libya started just a couple of hours ago, with the initial appearance of Mr. Rishwi before the court, following his transfer by Germany on Monday. We welcome these efforts in this case. This wouldn't be possible without successful cooperation. Third, and most importantly, non-cooperation has concrete consequences on the life, hopes, and well-being of real people. This is an aspect that deserves more attention. Let me give you a few examples. After the return of al-Masri by Italy to Libya, victims in Tripoli told LFCL about their fear of reprisal, as al-Masri was now aware that they had provided critical information to the OTP to build their case against him. Similarly, 6 outstanding arrest warrants for crimes in Taruna offer victims a rare sense of hope, but with no arrests made and suspects again becoming influential in the city, many victims now feel abandoned. These concerns are not unique to Libya, nor are they new. They rather illustrate that there is an urgent need to effectively address non-cooperation, and it is in your power, in the power of state parties, to do so. How? First, fully respect all aspects of your cooperation obligations under Part 9 of the Rome Statute, equally across all situations and all suspects. Second, call on non-state parties to cooperate with the court, in particularly when situations have been referred to the court by the UN Security Council. This is, of course, only possible if state parties do not give in to double standards and consistently cooperate with the court themselves. Third, make clear that non-cooperation also includes instances where civil society organizations, activists, and others supporting the court work are subjected to threats and reprisals. Fourth, ensure that there are real consequences and political costs for non-cooperation. This should involve evaluating the effectiveness of current non-cooperation findings and referrals and considering further or alternative measures. Last, continue to support the Rome Statute system. This implies supporting civil society organizations working for justice, including financially, politically, and ensuring that they can do their work unhindered from threats and reprisals. It also implies publicly defending the ICC from ongoing threats and providing the court with adequate resources to implement all aspects of its mandate, including victim and witnesses protection measures, as victims and witnesses are ultimately the ones who are mostly impacted by non-cooperation. Thank you.
Thank you very much for your interesting contribution, and I would thank all the panelists for their most interesting and enlightening remarks. And without further ado, I would turn to the participants who have requested the floor, kindly recalling that the interventions are limited to a maximum of 3 minutes and will be delivered from your seats. And I would now give the floor to Mr. Claudio Troncoso Repetto, Legal Director of the Ministry of Foreign Affairs of Chile. You have the floor.
Gracias, señora presidenta. Mi delegación agradece el informe presentado por la mesa y valora su permanente trabajo para fortalecer el sistema del Estatuto de Roma. Este esfuerzo es fundamental para el cumplimiento del mandato de la Corte y para asegurar que la justicia internacional continúe siendo una herramienta efectiva contra la impunidad. Sin embargo, observamos con preocupación los casos persistentes de falta de cooperación por parte de algunos estados, especialmente respecto de la ejecución de órdenes de arresto. Estas situaciones afectan, señora presidenta, un pilar esencial para la operatividad de la Corte y debilitan gravemente su capacidad para cumplir su mandato. Por ello, hacemos un llamado a los Estados partes a utilizar de manera activa y temprana los mecanismos de consulta con la Corte cuando enfrenten dificultades para implementar sus obligaciones. Solo mediante un diálogo oportuno y comprometido podremos asegurar el cumplimiento eficaz de las disposiciones de la parte 9 del Estatuto. Asimismo, Chile observa con seria inquietud la reciente denuncia del Estatuto de Roma efectuada por un Estado parte y las informaciones que sugieren que otros Estados podrían seguir ese camino. Este hecho constituye una alerta que debe impulsarnos a reforzar nuestro compromiso colectivo con la justicia internacional. La cooperación, tanto de los Estados partes como de aquellos obligados por decisiones del Consejo de Seguridad, es indispensable para la eficacia del sistema. La falta de cooperación, en particular en detenciones y entregas, afecta al desarrollo de las actuaciones judiciales y compromete la posibilidad de asegurar justicia a las víctimas. Valoramos también los informes de la Fiscalía al Consejo de Seguridad en las situaciones Darfur, Sudán y Libia y respaldamos su llamado a adoptar medidas concretas para fortalecer la cooperación y garantizar la ejecución de las órdenes de detención. Finalmente, reconocemos los esfuerzos de la presidenta de la Asamblea y de la Mesa para recordar la importancia de cumplir con las obligaciones de cooperación. Chile reafirma su compromiso con la Corte Penal Internacional e insta a todos los Estados a fortalecer la cooperación y defender colectivamente la vigencia del Estatuto de Roma. Muchas gracias, señora presidenta.
Thank you very much, Mr. Troncoso Repetto. I now invite Ms. Alicia Patricia Perez Galeana, Deputy Legal Advisor for Treaties and International Fora at the Ministry of Foreign Affairs of Mexico. You have the floor.
Señora Presidenta, muchas gracias por darme la palabra. Excelencias, estimados colegas. La plena cooperación con la Corte continúa siendo uno de los desafíos más serios para el sistema de justicia penal internacional. Cuando un Estado parte no ejecuta una orden de arresto o no atiende una solicitud de la Corte, ello no solo implica un incumplimiento de las obligaciones internacionales aplicables, sino que son las víctimas quienes resienten las consecuencias directas de la impunidad. Las posibilidades de verdad, justicia y reparación se ven retrasadas o anuladas, mientras que la comunidad internacional pierde su confianza en la capacidad para rendir cuentas por estos crímenes. La Asamblea ha reiterado que la cooperación plena es una obligación jurídica derivada del Estatuto de Roma, especialmente en la ejecución de órdenes de arresto. Su falta de ejecución menoscaba todos los esfuerzos materiales, institucionales y personales de décadas de trabajo dedicadas a la búsqueda de la justicia. Por ello, la Asamblea ha desarrollado procedimientos para tratar estos casos, incluyendo aquellos en los que la Corte refiere formalmente un incumplimiento conforme al artículo 87, numeral 7. La utilización de este procedimiento es preocupante, puesto que refleja la falta de cooperación de algunos Estados. En línea con la jurisprudencia reciente, el umbral de este artículo se alcanza cuando el incumplimiento impide funciones esenciales de la Corte, como asegurar la comparecencia del acusado. Bajo el artículo 97 del Estatuto, cuando un Estado parte identifica dificultades que pueden impedir o retrasar la ejecución de una solicitud de cooperación, existe una obligación jurídica de consultar sin demora con la Corte, a fin de encontrar soluciones que permitan cumplir con dicha solicitud. Su propósito es evitar que esas dificultades se traduzcan en una situación de no cooperación, por lo que esta herramienta resulta esencial. Invitamos a todos los Estados parte a familiarizarse con los procedimientos de la Asamblea sobre no cooperación y con las herramientas para la implementación. La falta de cooperación también se manifiesta en medidas que cuestionan los compromisos asumidos bajo el Estatuto o que plantean la posibilidad de limitar obligaciones establecidas en el mismo. En momentos de polarización y presión hacia la Corte, el sistema multilateral debe reafirmar con contundencia que la justicia por crímenes internacionales requiere continuidad, coherencia y compromiso sostenido más allá de consideraciones políticas. Los puntos focales de no cooperación, entre ellos México, buscan precisamente articular esta visión, al buscar que el diálogo entre Estados y la Corte sirva para prevenir y atender incumplimientos de forma coordinada. Por ello, instamos al fortalecimiento de su labor. Por otro lado, la falta de cooperación representa un riesgo para la universalidad, independencia, efectividad y credibilidad de la Corte. Frente a este desafío, debemos promover un entorno donde las obligaciones derivadas del Estatuto puedan cumplirse sin obstáculos. Distinguidas delegaciones. La cooperación hace posible que una orden de arresto no sea un concepto abstracto. Cooperar permite asegurar que una víctima no espere décadas para obtener justicia. Es afirmar la vigencia del Estatuto de Roma. De lo contrario, se debilita la capacidad del sistema de justicia internacional. Esta Asamblea puede abordar este desafío de forma conjunta, con la mirada puesta en las víctimas y en la necesidad de preservar el sistema penal internacional. Cumplir con estas obligaciones honra nuestro compromiso con el castigo de los crímenes más graves que afectan a la comunidad internacional, que no pueden ni deben quedar impunes. Muchas gracias.
Thank you, Ms. Perez-Galeana. I now give floor to Mr. Rasmus Bøck Johansen, Director at the Ministry of Foreign Affairs of Denmark.
Thank you, Madam President, and good afternoon, Excellencies, colleagues. Let me also express our appreciation for this special segment and the interesting interventions by the panelists. A very important topic because non-cooperation severely undermines the court's functions and requires our continued attention. One of the most fundamental principles in the Rome Statute is the obligation for all state parties to fully cooperate with the court. Non-compliance sends a completely wrong message of impunity to alleged perpetrators and victims alike. In the same vein, state parties must avoid all non-essential contacts with individuals facing arrest warrants. Today's concept note invites us to focus on Article 97 of the Rome Statute and its role for consultations between the relevant state and the court. As mentioned by others, it's worth remembering that Article 97 is a non-exhaustive list of topics states can raise with the court. For example, besides treaty obligations, states may also raise obligations under customary international law as a potential concern that may affect the request to cooperate. So in this regard, we would like to ask the panelists the following. Some of you have already touched upon it, but might be able to elaborate. Could the consultations under Article 97 serve not only as a forum for addressing concerns with stems from an imminent issue, such as the immediate execution of an arrest warrant, but maybe also from more general or principled matters where, for example, the interpretation of general international law is at issue. As an example, questions could arise regarding the potential hosting of peace talks with individuals under arrest warrants. So could such matters be raised as a preliminary question through consultations under Article 97? Furthermore, there are different views regarding the question of personal immunities when it comes to officials from third states in situations where there's no referral from the UN Security Council. And there may be other issues of general international law in relation to third states. So again, consultations under Article 97 could provide member states and the court with an opportunity to exchange views and thereby preventing non-cooperation. So to sum up, in our view, Article 97 seems to have some untapped potential before concrete situations arise, with the purpose of improving cooperation, obviously. So we would appreciate the views of the panel on this matter. Thank you.
Thank you, Mr. Johansen, and I would now invite Mr. Mizune Mizuaki, Director, International Judicial Proceedings Division, International Legal Affairs Bureau, Ministry of Foreign Affairs of Japan. I give the floor.
President, we welcome the decision to have a non-cooperation plenary session and appreciate this opportunity to share Japan's views on this critically important subject. For the ICC to truly fulfill its role as a sustainable and effective judicial institution, robust cooperation of all state parties is indispensable. However, we note with concern the repeated decisions of non-cooperation by state parties, which may raise questions about the ICC's credibility. In addition, the case in which withdrawal from the court was declared after its non-cooperation finding may affect the future realization of the universality of the ICC. For the ICC's long-term development, it seems that simply condemning non-cooperation is not constructive and does not resolve this issue. It is more meaningful to review the process, including consultations that may have taken place between the court and state parties that ultimately led to non-cooperation. It is useful to discuss and clarify, based on relevant provisions of Rome Statute, such as Articles 87, 97, and 98, how state parties and the ICC can and are required to respond in such challenging cases. Japan remains a strong supporter of the ICC. We are committed to actively participating in such vital discussions, working in close cooperation with other state parties to ensure the court can effectively perform its essential role in the fight against impunity and in promoting the rule of law. I thank you, Madam.
Thank you, Ms. for your statement. Et maintenant, je donne la parole à Madame Sandrine Barbier, directrice adjointe du Bureau des affaires juridiques du ministère français des Affaires étrangères. Vous avez la parole.
Merci. Merci, Madame la Présidente de l'Assemblée des États parties. Mesdames et Messieurs, la France salue l'organisation pour la première fois d'une séance plénière dédiée à la non-coopération. La coopération est un fondement du système du statut de Rome. Dès lors, toute attitude de non-coopération constitue nécessairement un obstacle à la réalisation de la mission confiée à la Cour. L'Assemblée des États parties a d'ores et déjà accompli un grand travail sur cette question et le panel d'aujourd'hui rappelle la diversité des outils à la disposition des États. Le protocole d'accord relatif aux consultations prévu à l'article 97 alinéa C adopté en 2017 demeure un outil pertinent. Le processus qui avait conduit à son adoption par la mise en place d'un groupe de travail dédié a montré tout son intérêt en ce qu'il favorise l'émergence de solutions nouvelles. Une telle méthodologie pourrait être répliquée pour approfondir le protocole de 2017. En juillet 2025, les co-facilitateurs pour la coopération ont fait intervenir les points focaux sur la non-coopération afin d'échanger sur la prévention des situations de non-coopération. De tels échanges devraient se poursuivre. Enfin, plusieurs bonnes pratiques peuvent être identifiées. S'agissant de la prévention, une première consiste en l'adoption d'une législation nationale de mise en œuvre du statut de Rome, comprenant des procédures dédiées à la coopération avec la Cour. À ce titre, je souhaite souligner l'utilité de la plateforme pour la coopération qui permet à la Cour de disposer des informations actualisées sur les législations nationales. Une deuxième bonne pratique est l'identification d'un canal de transmission pour les demandes urgentes et la conclusion d'un protocole relatif à l'exécution des demandes d'arrestation et de remise à la CPI. La France y travaille actuellement avec le greffe et le bureau du procureur. Cet outil permet aux États de mieux maîtriser la procédure à appliquer et de limiter les risques de non-coopération dus à une procédure insuffisamment préparée. Troisièmement, s'agissant des situations de non-coopération, nous encourageons les points focaux pour la non-coopération à mener un travail de sensibilisation renforcé auprès des États de leur groupe national. Il pourrait également s'appuyer sur les États ayant une relation privilégiée avec l'État en situation de non-coopération pour faciliter le dialogue et identifier les raisons de cette non-coopération pour les corriger lorsque cela est possible. La France demeure pleinement engagée pour poursuivre tous ces échanges afin de renforcer la Cour et de soutenir l'intégrité du système du statut de Rome. Je vous remercie.
Merci de votre intervention. And I will now invite Ms. Monica Furness, Director Legal Affairs, Minister of Foreign Affairs of the Kingdom of Norway. You have the floor.
Full and timely cooperation with the court is not only a legal obligation under the Rome Statute, but a cornerstone of the credibility and effectiveness of the international criminal justice system. Preventing non-compliance requires proactive engagement. Article 97 consultations are a critical tool in this regard. They provide a structured avenue for states parties to address challenges that may impede execution of cooperation requests before they escalate into non-compliance. States should initiate such consultations without delay and conduct them in good faith to ensure that practical obstacles do not undermine the court's mandate. In times when the court faces significant challenges, our collective commitment to cooperation becomes even more important. Challenges to its independence and authority, whatever their nature, should not weaken the resolve of states parties to fulfill their obligations. On the contrary, this calls for stronger unity and unwavering adherence to the statute as a signal of confidence in the court and in the system of international justice. Selective cooperation and double standards must be firmly rejected. This is a shared responsibility, and Norway remains fully committed to doing its part. Madam President, Norway encourages all states parties to make active use of the Assembly's procedures on non-cooperation and the accompanying toolkit. These mechanisms, including the good offices of the President and focal points, offer practical support to resolve difficulties swiftly and discreetly. They should be seen not as punitive measures, but as instruments to foster dialogue and solutions. Ultimately, our collective responsibility is clear: to uphold the integrity of the Rome Statute system by ensuring that arrest and surrender requests are executed effectively. Thank you.
Thank you, Ms. Furness, for your statement. And I will now give floor to Marion Crepé, legal advisor at the permanent representation of Liechtenstein to the United Nations. You have the floor.
Thank you, Madam President. Liechtenstein welcomes the decision adopted at the last session of the Assembly of State Parties to include a debate on non-cooperation issues to our agenda. We believe that these debates provide an essential opportunity for states parties to reflect on their obligations to cooperate with the court and more broadly to uphold the principles of the Rome Statute. We also thank the panelists for their important contributions to these conversations today. The establishment of the International Court to prosecute genocide, crimes against humanity, war crimes, and the crime of aggression stand as one of the most significant achievements in treaty making in recent decades. However, the provisions of the Rome Statutes are very clear. The court cannot fulfill its mandate to promote accountability for the most serious crimes without the full cooperation of its state parties. The lack of cooperation observed this year is concerning. It shows not only a failure to comply with legal obligations, but also a failure to comply with the common pledge that we've made in Rome, that nobody is above the law. We trust that today's discussions will help prevent future instances of non-compliance and also pave the way for stronger cooperation ahead of the next Assembly of State Parties. As illustrated in our discussions today, we have a clear and robust legal framework to guide us moving forward. Article 97 of the Rome Statutes allows states and the courts to work together to resolve problems in executing cooperation requests and also reduces situations where cooperation may be denied. The court jurisprudence has consistently clarified these obligations. The Assembly consultations on Article 97 deepened our understanding of these processes, and the Assembly's toolkit on non-cooperation provide practical guidance to help states fulfill their responsibilities. We greatly appreciate the valuable insights shared today by the panelists on lessons drawn from past consultations. It was particularly insightful to hear and to reiterate the vast arrays of informal response procedures at the disposal of states parties to overcome potential challenges. Madam President, with a clear legal framework, practical tools, and regular exchange on cooperation such as today, we have all the necessary means to address non-cooperation challenges in a consistent manner. It is now our task to translate this into tangible results. I thank you.
Thank you, Ms. Crepé, for your statement, and I will give floor to Ambassador Augusto Massari of Italy. You have the floor.
Thank you, Madam President. Let me first express my appreciation for this debate on the issue of non-cooperation. We are are having the possibility to discuss important aspects relating to this issue with a view to reaching a common understanding of possible challenges and suitable solutions to improve our support to the court. Since a case concerning my country has been mentioned, I deem it appropriate to take the floor and share our position on this matter. It is not possible to engage in any discussion concerning alleged non-compliance by my country in the absence of a formal referral under Article 87/7 of the Rome Statute and a specific non-cooperation resolution adopted by the Assembly of the State Parties pursuant to Article 112 ACC ASP/10/Res. 5 as amended in 2017. Nonetheless, let me recall that Italy has proactively engaged with the court and cooperated by providing timely, transparent, and comprehensive responses. We will continue to engage in good faith with the court with a view to reaching the inherent goal of the ongoing procedure, which is identifying, where needed, possible ways to improve the cooperation between state parties and the court, based on clear, predictable, and effective procedures. Italy fully reaffirms its commitment towards its obligation under the Rome Statute and towards the fight against impunity for the most serious international crimes. Thank you, Madam President.
Thank you, Ambassador Massari, for explaining your position. And indeed, the question of Italian non-cooperation has not been referred to the Assembly of State Parties. And I would now give floor to Howard Jan Bijl de Vroo, Ambassador, Permanent Representative to the Organization for the Prohibition of Chemical Weapons and to the International Criminal Court in The Hague. You have the floor, Ambassador.
Thank you, Madam President, dear Päivi, for giving me the floor. We reiterate our unwavering support for the court and for the effective implementation of the Rome Statute. Without cooperation from states parties, the court can't carry out its important mandate. The Kingdom of the Netherlands acknowledges the obligation for all states parties to cooperate for the purpose of the investigation and prosecution of crimes under the Rome Statute on the basis of Article 86, Part 9 of the Rome Statute. The Kingdom of the Netherlands appreciates the decision of the Assembly to address non-cooperation issues during this ASP. This offers an important opportunity to strengthen our collective response, discuss challenges that may arise, and work towards solutions that prevent situations of non-cooperation. The Kingdom of the Netherlands fully endorses that any finding of non-compliance must be followed by timely and transparent responses from the ASP. Non-cooperation is not a standalone issue, but it affects the court as a whole. Article 97 of the Rome Statute provides for an essential instrument to consult with the court in order to discuss problems a state party may identify, which may impede a request for cooperation by the court. The important steps taken in this regard, in and since 2017, have provided useful procedures in relation to non-cooperation. The Kingdom of the Netherlands underscores the importance of further use and implementation of the Assembly procedures relating to non-cooperation and the accompanying toolkit. These resources provide structured and practical guidance that helps states and the Assembly respond consistently to situations of non-cooperation. We encourage all states parties and relevant stakeholders to use these tools proactively, both to prevent and resolve potential issues of non-cooperation. The Kingdom of the Netherlands looks forward engaging in efforts initiated by the court and the ASP to this effect. Thank you.
Thank you very much for your statement, Ambassador. And next speaker will be Mr. John Camargo from the Directorate of Judicial International Affairs of Colombia. You have the floor.
Muy buenas tardes, señora presidenta, distinguidas delegaciones. Colombia agradece la convocatoria de esta sesión plenaria dedicada a la prevención del incumplimiento de las obligaciones de cooperación de los Estados parte. En nuestro carácter de Estado firmemente comprometido con el sistema del Estatuto de Roma, reconocemos que la cooperación plena, oportuna y de buena fe constituye un pilar esencial para que la Corte pueda cumplir su mandato de manera independiente y efectiva. La plena cooperación con la Corte Penal Internacional no es una aspiración política, es la piedra angular del Estatuto de Roma. Cada incumplimiento erosiona la capacidad del sistema para actuar, debilita su credibilidad y se erige como un obstáculo para la lucha contra la impunidad. Este no es un desafío nuevo, tal como lo señalaron el pasado lunes la presidenta de la Asamblea, Paivi Caurocanta, y la presidenta de la Corte, Tomoko Akan. La falta de cooperación ya ha sido identificada en el pasado dentro del sistema. En este contexto, la experiencia acumulada por la Asamblea y por la Mesa, particularmente desde la actualización de los procedimientos sobre no cooperación, demuestra que la prevención es más eficaz que la reacción. Por ello, Colombia valora profundamente los mecanismos tempranos, incluidas las consultas formales y sustantivas previstas en el artículo 97, que permiten identificar y resolver dificultades potenciales antes de que se materialicen en situaciones de incumplimiento. Asimismo, destacamos el papel positivo de los puntos focales regionales, cuyos esfuerzos de diplomacia preventiva han fortalecido la comunicación con la Corte y han contribuido al desarrollo de sistemas nacionales más robustos, evitando incidentes que podrían socavar la credibilidad colectiva del sistema. En la misma línea, Colombia resalta el valor del toolkit de los buenos oficios de la Presidencia y, por supuesto, de los procedimientos establecidos por esta Asamblea, en tanto son instrumentos que complementan de manera eficaz las consultas del artículo 97. Sin perjuicio de estos avances, los casos recientes en los que la Corte ha constatado la falta de cooperación muestran que persisten aún desafíos significativos, en particular cuando la no cooperación responde a una falta de voluntad política. Resulta indispensable que la respuesta a esta Asamblea sea unificada. Para Colombia, reforzar los procedimientos sobre no cooperación es fundamental para garantizar que sigan siendo herramientas imparciales, previsibles y coherentes con la responsabilidad compartida que los Estados partes tienen en la administración de la justicia penal internacional. La posición de Colombia es clara. El respeto a la autoridad judicial de la Corte es esencial para el funcionamiento del sistema. La eficacia del Estatuto de Roma depende del compromiso político continuo de todos los Estados partes. La cooperación no es solo una obligación jurídica, sino que corresponde a una manifestación concreta de nuestra adhesión colectiva a la lucha contra la impunidad. Colombia reafirma finalmente su compromiso con el multilateralismo y con el estricto respeto al derecho internacional, así como su disposición a trabajar constructivamente con la Corte y con los Estados parte. En este sentido, invitamos a todos los Estados partes a continuar fortaleciendo los mecanismos preventivos, promover el cumplimiento del Estatuto y consolidar un sistema de justicia penal internacional más fuerte, más coherente y mejor preparado para responder a los desafíos actuales. Muchas gracias.
Thank you very much for your statement, and I will give floor next to Victoria Wagner, Head of International Criminal Law at the Austrian Foreign Ministry.
Thank you very much. Dear colleagues, thank you for organizing this plenary on the very important topic of non-cooperation. Cooperation of states parties is essential for the functioning of the court. The court cannot fulfill its mandate if state parties do not furnish information and evidence, establish contacts to witnesses and victims, or implement arrest warrants. Therefore, ensuring the ability and commitment of state parties to fully observe their obligations under the Rome Statute should be a paramount goal of all of us, states parties and the court alike. Unfortunately, more recently, we have seen a number of instances where state parties did not cooperate, with different reasons and motivations. But let us be clear, in 95% or 99% of cases where the court requests the legal cooperation and assistance of state parties, such cooperation works just fine. There is no issue about it. States parties want to cooperate, they want to support the court. However, there are circumstances where cooperation fails. In such circumstances, we should ask, is a state party committed to cooperate, but is unable to do so, for example, if there is a competing obligation or objective under international law? Sorry, I'm so sorry. This always happens in moments like this. In a case where a state party is committed to cooperate but feels unable to comply, Austria would argue that we need to find solutions in order to avoid cases of non-cooperation. To this end, we propose to have an open, frank, and practical dialogue among states parties and with the court. Our goal is to find a common ground, firmly based upon the Rome Statute and international law, to ensure the ability and commitment of states to fully observe their obligations under the Rome Statute. The goal of such a dialogue should be to clarify and manage expectations of both states parties and the court about the procedure of consultations under Article 97 of the Rome Statute and the possibility of circumstances firmly grounded in international law where the obligation to cooperate might be legitimately suspended, such as hosting peace negotiations in the context of an armed conflict. Let me be clear. Austria does in no way want to preempt the outcome of such a dialogue on cooperation. We simply see important questions in the context of cooperation which warrant answers based upon a realistic, frank, and practical dialogue among states parties and with the court. I want to close my statement by reiterating Austria's steadfast commitment to the court and to fulfilling our obligations under the Rome Statute. Thank you.
Thank you very much for your statement and for the wake-up call for all of us to cooperate with the court. And the next speaker will be Ambassador Sandra Lendemann, Vice Director of the Directorate of International Law at the Ministry of Foreign Affairs of Switzerland. You have the floor.
Madam President, Excellencies, esteemed delegates, thank you. Cooperation and non-cooperation of states parties with the court have been a recurring theme since its foundation. Indeed, cooperation is essential to the court's work. We, the states parties, constitute the court's only enforcement mechanism. Without judicial cooperation of its member states, it would be a judicial body without teeth. At the same time, we are all aware that cooperation may come with complex obstacles for states parties. This is precisely why Switzerland considers Article 97 consultations an important tool to strengthen cooperation with the court. They offer a mandatory but cooperative framework for states parties to raise genuine difficulties and work with the court in good faith towards practical solutions. These consultations should be conducted in a constructive manner, solution-oriented and taking into account the specific circumstances of each case in order to identify workable ways to ensure effective cooperation. The International Criminal Court serves as a vital pillar, not only for international justice, but more broadly also to ensure sustainable and long-term peace and security. Hence, justice and peace go hand in hand. They should be pursued in a mutually reinforcing manner, serving the purposes and principles of both the Rome Statute and the UN Charter. Accordingly, Article 97, in our view, provides space to consider questions arising in the context of peace processes involving individual subjects to ICC arrest warrants. In such very exceptional situations, it is important to keep in mind the broader context. Cooperation issues should not be an impediment for achieving peace. Over the past days, we as states parties have all reaffirmed our strong support for the court in these very demanding times. Making full and constructive use of Article 97 consultations should help both the court and the states parties to overcome cooperation challenges and to reinforce the court's ability to carry out its mandate. Thank you.
Thank you for your statement. And next speaker will be Mr. Muzaffar Museyzoh, Ambassador of Tajikistan. You have the floor.
Thank you, Madam President. The current geopolitical dynamics highlight the imperative for strengthened dialogue and enhanced collaboration. Tajikistan is a state party to the International Criminal Court since its establishment. All provisions set out in the Rome Statute are reflected in Tajikistan's national legislation, notably in the Criminal Code, underscoring the country's commitment to its goals, principles, and obligations. My country supports the development of international judicial institutions, which must remain impartial, fair, and aligned with international standards and principles of legal neutrality. However, recent developments highlight the complex and diverse approaches to international justice and may create additional challenges. By emphasizing the importance of the rule of law and accountability, we recognize the need to further promote dialogue, strengthen the capacity of national institutions, and ensure that the tools necessary for a better understanding of ongoing challenges and issues are readily available. Tajikistan reaffirms its readiness to further strengthen collaboration with the states parties, the ICC, and its relevant institutions in the view of fostering mutual trust and collaboration. And regarding the issue under discussion, I would like to underline that my country is very much engaged in a very constructive and faith manner with the registry through regular meetings and consultations to address the issue and to find a necessary toolkit. Thank you very much.
Thank you very much. And the next speaker will be Ms. Lauren Saeed, legal advisor of the State of Palestine and at the permanent representation of Palestine in New York. You have the floor.
Thank you, Madam President. Allow me to begin by expressing our appreciation to you for holding this panel. We reiterate that the central role of cooperation and assistance between states parties and the court, including on arrest warrants, and we recall that the Rome Statute has the procedures and mechanisms that enable states parties to cooperate with the court, such as Article 97 and the tools adopted by the ASP. The State of Palestine recalls that neither request for consultations nor the consultations, or any outcome of consultations has suspensive effects vis-a-vis the arrest warrants, nor has any effect on the judicial independence. The consultations under Article 97 is not a medium to undermine the court's decisions or jurisprudence, including on personal immunity of officials, and we reiterate that the court can have jurisdiction over non-members nationals who commit crimes in a member state territory, provided that there is a territorial jurisdiction established, and certainly not limited to a Security Council referral. Whether these persons are nationals of states parties or nationals of non-states parties is irrelevant. The statute does not make any distinction in this regard. This is important to promote accountability for serious crimes and create a binding legal obligation for states parties to uphold its standards in both domestic and international contexts, ensuring that the objectives of the statute are fully achieved. The duties a states party has both towards the court and other states parties pursuant to the statute supersedes its relation with the state of the nationality of the sought person, regardless of whether that state is or is not a party. Also, obligations under the Rome Statute cannot be altered or superseded by any bilateral commitments, processes, or exceptional circumstances that may conflict with the Rome Statute's objectives. States that have accepted the jurisdiction of the court have therefore the obligation to arrest and surrender any person for whom the court has issued a warrant of arrest, irrespective of their official capacity and nationality, and in compliance with Article 27 of the statute on which the entire court system stands. Any other interpretation, including as they are related to Article 97, would fatally render the obligations of states parties senseless and the overall court system futile. Should a state party use Article 97 in an effort to grant personal immunity, it would be acting inconsistently with its international obligations under the statute, which may amount to a violation of international law. Thank you.
I thank you for your statement. And next, the speaker will be Sierra Leone. I give floor to George Kamanda. You have the floor.
Thank you, Madam President. Sierra Leone is one of the ARC County focal points aligned with the statement delivered by the distinguished representative of Vanuatu on behalf of the ARC County focal point and wishes to make this short intervention in national capacity. Sierra Leone welcomes the BO's report on non-cooperation and reaffirms its unwavering support for the International Criminal Court and the Rome Statute system. We believe that where cooperation falters, justice suffers. Non-cooperation must be addressed proactively, not retrospectively. We commend the Assembly for dedicating space to this discussion. Article 97 consultations are vital tool for prevention. They must be used early, conducted in good faith, and never treated as a basis for delaying or suspending cooperation. Sierra Leone encourages all states to also operationalize the toolkit on non-cooperation and to make greater use of informal good offices. These mechanisms promote dialogue, preserve institutional trust, and help avoid formal non-compliance procedures. As one of the ARC County focal points, we have worked alongside Finland, Mexico, Poland, and Vanuatu to support quiet diplomacy and monitor risk. We welcome further engagement by state parties facing implementation challenges and stress the need for clear communication with the court, especially with the registry and the office of the prosecutor. In closing, we urge all states to uphold their cooperation duties under the Rome Statute and to engage constructively when challenges arise. As a means to further this dialogue and among state parties, we welcome views on how the Assembly can better systematize support for Article 97 consultations as a preventive tool, especially for states acting in good faith. Thank you, Madam President.
Thank you for your statement. And next speaker will be Marko Rakovic, Director General for International Law at the Ministry of Foreign Affairs of Slovenia. You have the floor.
Thank you, Madam President. Slovenia welcomes the debate on non-cooperation. It is very useful to have this dialogue between states parties and to exchange views. Non-cooperation is not a new issue, considering 31 unexecuted public arrest warrants and, to some extent, unpreparedness to actively approach to their implementation. We have witnessed visits of individuals under arrest warrants in state parties. Obligation to cooperate with the court is a legal obligation. What's more, there is a legal obligation to act in a manner that allows for and sets the ground for efficient fulfilling of the mandate of the ICC. With this purpose, basic steps have to be followed and foreseen tools have to be used to, in the first place, prevent situations where a state party would face concerns or reproaches about failure to cooperate. Slovenia calls on all state parties to begin the consultations with the court as soon as possible before a potential situation would arise. Regarding the rule of law, the objective of the Rome Statute is clear and no one should be above the law. Anything contrary to this would undermine the global fight against impunity for atrocities. Additionally, the statute is a lex specialis in many respects, and it is on the court to construe the statute and adjudicate. We, state parties, are obliged to respect and implement the Rome Statute. We are also obliged to respect the independence of the court, its jurisdiction, and jurisprudence. Thank you.
I thank you, and that brings us end of the states parties representatives that have requested for the floor. As no observer state or court representatives have requested the floor, I would now move to the speakers on the list of NGOs. And the first speaker will be Ms. Maria Gevorgian, legal researcher, lawyer, Center for Truth and Justice. You have the floor.
Thank you. Thank you, Madam President. Excellencies, distinguished delegates, dear states parties, it is my pleasure to address you on behalf of the Center for Truth and Justice, a human rights organization documenting atrocity crimes. Critics claim that the ICC is becoming a toothless tiger. Some even say that the ICC cannot do anything on its own. Well, I have bad news for those who hide behind the narrative. The strength of the court was never meant to come from its claws. It comes from yours. As it's clear from this session, the Rome Statute is explicit. Under Article 86, states parties shall cooperate fully with the court. Under Articles 87 and 89, the court may issue requests to states parties for cooperation, including requests for the arrest, but those requests only breathe, walk, and act through you. And yes, we hear the refrain, the international community must help the court. But let us be clear, you are the international community. There is no abstraction out there waiting to assist. And as the pretrial chamber itself alluded to in the Myanmar jurisdiction decision of the 2018, and I quote, 120 states representing the vast majority of the members of the international community had the power to bring into being an entity possessing objective international legal personality, the ICC, with the capacity to act against impunity. End of the quote. If the tiger seems toothless, it's because those who forge its teeth now hesitate to let it bite. As an organization documenting crimes committed against ethnic Armenians, victims from a state that has only recently joined this court, I want to speak of what cooperation means to victims. For many of them, accession was not a technical step. It was a fragile, precious hope that law could finally stand where politics had failed. And these victims ratified their hope when Armenia joined this court in 2024. They believed that when arrest warrants were issued, they would be respected and that justice would follow the law. But then, Italy, a founding state party, the country where this entire project began, released the suspect wanted by this court and allowed him to return home instead of surrendering him. An arrest warrant, a binding obligation, and yet a failure. What do I say to victims? How do I explain, as a lawyer, that even a founding state can set aside the very rules it wrote? This is why today's discussion is not procedural, it's existential. Dear states parties, when you say that the ICC needs the international community's help, remember you are the vast majority of it. Thank you.
I thank you for your remarks, and I now invite Ms. Alina Pavliuk, coordinator of the Analytical Department of Lawyers' Work, Ukrainian Legal Advisory Group. You have the floor.
Thank you. Distinguished representatives, states cooperation is a crucial guarantee which determines the effectiveness of the ICC's work. But for the last year, we as Ukrainian civil society have seen much frustration from victims of grave crimes when the ICC's arrest warrant become a nominal exercise for states that welcome people who are the focus of international justice efforts on their territory. Such a tendency among the states parties leaves an open path to impunity for suspected war criminals, such as the Russian president. This means that they will choose to commit more atrocities without feeling the consequences of their choices. For victims of great crimes committed on the course of Russia's war against Ukraine, the International Criminal Court remains a key mechanism for ensuring accountability of the Russian leadership. The ICC arrest warrant is a compelling recognition that Vladimir Putin may be responsible for the unlawful deportation of Ukrainian children, has so far largely prevented him from freely traveling the world. For victims and survivors, it maintains a vital hope for justice, serving as a reminder that while he may not yet be arrested, the perpetrator cannot enjoy impunity. Hosting a welcoming and forgiving from international justice would contravene obligation to cooperate fully with the ICC and undermine the shared commitment to accountability that lies at the heart of the Rome Statute system. We recall the states parties to ensure fully their commitment to the court by actions vis-à-vis cooperation. We would like to take this opportunity to remind you that behind each arrest warrant issued by the court are hundreds and thousands of victims who have suffered and continue to suffer from atrocities, while including a suspected war criminal in affair of political or economic advantages. Even for the noble cause of peace facilitation, cooperation must not be sacrificed in the name of political maneuvering for what is often an elusive possibility of progress, as seen in Ukraine's context. We see that there are ways to ensure diplomatic progress without each time undermining the authority of ICC arrest warrants, increasing the risk that there will be neither peace nor justice achieved. Please remember that each time a state party makes a choice to not cooperate, not only do they undermine the very fabric of the court, they fail humanity in favor of perpetuating impunity and their own interest. To this end, we call on state parties to choose the court, to choose humanity, and to choose justice. Thank you for your attention.
I thank you for your remarks. And the next speaker will represent Libya Crimes Watch. I'm not sure whether I have the right name, but on my list I have Anas Helal, Research Program Officer, Libya Crimes Watch. You have the floor.
Thank you, Madam President. Distinguished delegates, my name is Anas Hilal, and I address you today on behalf of Libya Crimes Watch to convey the voices of the victims and affected communities in Libya. Serious international crimes continue in Libya in a context of entrenched impunity. Despite Libya's obligation under Security Council Resolution 9070 and the Government of National Unity Declaration accepting the court's jurisdiction, the authorities have not engaged in meaningful cooperation with the ICC, and the acceptance has mainly remained on paper. Today, most of those subjected ICC arrest warrants remain at large, some integrated into state structures, while 3 of them are in detention but have not been surrendered to the ICC, with the authorities invoking the principle of complementarity to keep these cases international level. At the same time, the Libyan judiciary is not currently able to genuinely address such cases due to systematic shortcomings, lack of independence, and serious doubts about the impartiality and ability to prioritize victims' rights. The Libyan Attorney General often acts under political pressure rather than prioritizing accountability and the rule of law and the guarantees of non-recurrence. These patterns of non-cooperation is closely linked to how the principle of complementarity is being used. Complementarity should be a tool to advance accountability through genuine domestic proceedings, not a slogan to shield suspects from international justice. The case of Osama Jaim, who was returned from Italy to Libya at the Libyan Attorney General request, based on a claimed national jurisdiction, clearly illustrate the abuse of complementarity. And on this basis, we at Libya Crimes Watch put forward the following key recommendations. We call on the state parties and the court to use all available pressure to ensure that the Libyan authorities translate their acceptance of the ICC's jurisdiction into genuine cooperation, including surrender all the ICC suspects without exception. And we also urge the state parties to fully cooperate with the court on the Libya situation, including by executing ICC arrest warrants and arresting and surrounding any person sought by the court who is found on the territory or under their jurisdiction. And last, we recommended that the ICC reassess the application of complementarity principle in the Libyan context, given the lack of political will, weak independence, and the structural incapacity of the Libyan judiciary, including the Office of Attorney General, which currently renders domestic proceeding unable to deliver justice. Thank you.
I thank you. And I give floor to Mr. David Yambio, co-founder of Refugees in Libya, on behalf of the European Center for Constitutional and Human Rights. You have the floor.
Thank you so much. My name is David Yambio. I'm speaking here as a victim and I would like to address the crime of non-cooperation committed by Italy in the context of Libya. I am speaking as a victim of innumerable violence of Al-Masri and many torture camps across Libya. The wound that I carry today from those years is not something that I carry privately. These wounds are carried by every community that live under the shadow of impunity. Under your own treaty, when such a man is found in any member state on that soil, he is not only required by justice and law to be arrested, but he is required to be surrendered to the court. On the 19th of January in Italy, which is my host country, when this man was arrested, he was not handed to the International Criminal Court, but put on a state flight and flown back to Libya, where he continued to commit the crime. And to this date, he is on the loose. This forced me at a personal level with innumerable victims who were silent over the years in the hope and in the trust that this court exists and would deliver to us justice. It forced us to come out, to speak, to take on to the challenge, and to face many threats. And to this day, our lives have never been the same. In the carefully crafted speeches that I have heard here from member states, including the justification from the representative of Italy, you have spoken about accountability, about the suffering that persons like me and many victims around the world suffer. But what you have not acknowledged is that our lives depends on the decisions that you make, the consequences that we have to live. The many women who have been raped and will continue to be raped, those who have to be burnt by torture, those who have to be killed for no reason, and they put their belief and their trust in this court, have not been fully addressed. The non-complaints on Italy have not been fully addressed. And we as the victims stand and want to see this to be fully addressed, because when states like that cannot be held accountable, what about the individuals who are elected into those offices? In the context of Italy, I speak of the Prime Minister Giorgia Meloni, I speak of Minister of Interior Matteo Piantedosi, I speak of Minister of Justice Carlo Nordio, I speak of Alfredo Mantovano. These people, they have faces, and we know that they have committed a grave crime on our rights. We were denied justice by our perpetrators, yet they stayed here, it denied us a second chance in the court that we so much believe in. This afternoon, I was able to see one of the perpetrators. I was able to look at his face because Germany complied and managed to surrender him to the International Criminal Court. This is what we want to see in every state. We cannot live any longer inside those crafted speeches. We want concrete changes and accountability. Thank you.
I thank you for your statement, and I give floor to the last speaker on my list, Mr. Matthew Canuck, head of the Center of International Justice, Amnesty International. You have the floor.
Thank you, Madam President. Arresting all those subject to ICC arrest warrants is a clear and fundamental obligation of states parties. In this regard, Amnesty International recalls that states must stop at nothing to ensure that all persons subject to ICC arrest warrants are arrested and surrendered to the court. In 2025, 3 persons subject to ICC arrest warrants travelled to state parties without arrest. These instances of non-cooperation should have been met by condemnation and concerted responses at this Assembly session. At this Assembly session, A standalone session on cooperation has been included on the Assembly's agenda. This is a very welcome step, and such a session should be included as a standing agenda item on each year's agenda. However, while this session is welcome, we must recall that a referral of non-cooperation had been made to this Assembly, and while diplomatic statements are welcome, the Assembly has failed to act on this referral today. In our view, high-level suspects' travel to states parties without arrest should be seen as part of a strategy of seeking to undermine the court and the warrants issued against them. It is imperative that the Assembly demonstrates that the non-arrest of ICC suspects is not acceptable. Continued failure to do so is to allow the attempted erosion of the Rome Statute's obligations to succeed. In this regard, we firmly state that the positions emerging at this Assembly session, that cooperation obligations can be suspended for the purposes of peace negotiations, have absolutely no basis in the Rome Statute. The Assembly should urgently consider the effective implementation of procedures related to non-cooperation, which it had adopted in 2011. Indeed, where a states party fails in its obligation to arrest, and following a referral to the ASP by an ICC judicial decision, the ASP must consider the effective implementation of its procedures, which set out Assembly responses to such judicial findings. In addition, the Assembly should further consider its implementation of formal and informal responses to non-cooperation, including outlining possible proactive Assembly and States Party responses to instances to quote, where there are reasons to believe that a specific and serious incident of non-cooperation, including in respect of a request for arrest and surrender of a person, is about to occur or is currently ongoing, and urgent action by the Assembly may help bring about cooperation. At this Assembly session, with a number of suspects remaining at large and their whereabouts unknown, state parties must urgently consider their own performance shortcomings and how they can properly and fully meet their obligations in the Rome Statute as they relate to arrests and cooperation. Indeed, while states parties, including in the context of the budget discussions, frequently urge the court to demonstrate tangible results, it should be recognised that states parties themselves must assume significant responsibility for the lack of progress in cases where indicted persons have not yet been arrested. To repeat, arresting all those subject to ICC arrest warrants is a clear and fundamental obligation of states parties. This obligation extends to the arrest of heads of state, including President Vladimir Putin and Prime Minister Benjamin Netanyahu, who are subject to ICC arrest warrants. For the avoidance of doubt, the ICC Appeals Chamber has concluded that there is no head of state immunity under customary international law vis-à-vis an international court. This decision is binding on all states parties and provides that all states parties are unequivocally obliged to arrest all persons, up to and including sitting heads of state, and regardless of whether or not they agree or oppose a particular decision of the OTP or ICC in a particular situation. Thank you.
I thank you for your statement, and that brings our end of a list of speakers. Before concluding, I would I have one more request by the United Republic of Tanzania. I would give the floor, and therefore thereafter I will close the list of speakers, and I would then allow the representative of Registrar to answer to the questions put forward by Denmark. Representative Tanzania, you have the floor.
Thank you, Madam President. I thought you were concluding this one because I'm going to speak not on this particular agenda item, but because of the need to what has been said and the importance to correct and to put the record right. So I will be advised by your chair if I can speak now or after you've concluded the agenda item in discussion.
I think we will try to wrap up this issue concerning the non-cooperation, and I would allow you to intervene thereafter.
Thank you, Madam President.
But I will now allow the registry to answer the questions put forward by Denmark.
Many thanks, Madam President, and many thanks to the representative of Denmark for their questions. Allow me to say that Article 97 consultations can take place at any time, but of course it's always important to ensure that they're carried and triggered in a timely manner. This consultation should be related to a concrete request for cooperation that has been issued by the court on the basis of Part 9 of the Rome Statute. At the same time, states parties are also seized of provisional arrest requests, and they're also aware of the public existence or have public knowledge of the existence of arrest warrants issued by the court. So states are encouraged to approach the court and in particular the registry, the neutral organ of the court, through the judicial cooperation section represented here behind me by my colleague, Mr. Rastan, as well as colleagues that are in the room to engage on this issue. And they will be happy to provide guidance and to engage in this process. I would also like to reiterate that early engagement is always welcome and encouraged, and that our section in the registry is happy to provide technical guidance and advice early on in the context of cooperation, so that all efforts are put in place to avoid reaching a status of non-cooperation. Thank you very much.
Thank you, Antonia Pereira de Sousa, for this reply. I would just before closing say that of course this panel discussion and the discussion that we've held today is first of a kind. We have put a topic to be discussed because we thought that we would want to have a forward-looking, positive discussion on issues. Many of these are rather sensitive, and I would like to have a discussion that brings us forward on these issues. And in addition to this discussion, of course, the non-cooperation facilitation or the focal points have carried out discussion throughout the year. So this is not the only thing that has happened under the Bureau's mandate. And the report on non-cooperation is, of course, part of that. And it notes duly such decisions of the court, referrals of non-cooperation to the Assembly of States Parties, and of course we have to note that for example in the case of Italy the question of non-cooperation has not been referred to this assembly as of at the moment. So there is a legal reason why we have defined this discussion so that we are not addressing, for example, the question of non-cooperation by Italy. So I would hope that with these words we would make this format something positive, that we can continue our discussions, and since we all know that these are very sensitive issues, and in order to make this Article 97 and the non-cooperation procedures to function well, I think we should allow such discussions to go on, and on the other hand obey by the rules that we have in the Rome Statute and in the rules of that we have adopted on the non-cooperation procedures. But I would like to thank you very much, all the panelists today, all the speakers today. I think this has provided very good information on the practices used, as well as on the questions outlined in the concept note. And very much I'm happy to have witnessed a active participation by states and civil society organizations. I dared to hope in the beginning that this first non-cooperation plenary, it will become a forward-looking and solution-seeking platform and a dynamic tool that is useful to the court and the member states and the civil society likewise. I believe that this discussion has proved it right that this forum is necessary, and I look forward to further developments on this basis. Before, I promised to the representative of Tanzania that I would give her the floor before then announcing some technical timetable issues. Tanzania, you have the floor.
Thank you so much, Madam President. Madam President, I'm taking the floor just because of the need due to what has been said and the importance to correct and put the record right. On behalf of the government of the United Republic of Tanzania, I would respectfully like to reject the false and unfounded allegations presented by one of the speakers yesterday evening during the plenary, on where he wanted to draw the attention of the Assembly concerning reports from Tanzania regarding human rights situation before, during, and after the elections. Madam President, I would like to assure this Assembly that the situation on the ground is not what has been presented by the Speaker. The government of the United Republic of Tanzania remains fully committed in upholding human rights and continues to engage and work transparently and constructively. The United Republic of Tanzania encourages reliance on mutual respect and grounded, accurate information that it's ready to offer. I thank you, Madam President.
I thank you for your statement. And before closing, distinguished delegates, I would like to propose a change in the order of our work program for the remainder of the week. Since we have made much progress on the work of this session of the Assembly, I would like to suggest that we move the 8th plenary that is currently scheduled for Friday, 5th of December from 10 to 10:30 to the time slot is immediately after tomorrow's 7th plenary meeting on cooperation, which will run from 10 to 12. The 8th plenary, which will deal with reports of the coordinators and the introductions of resolutions, would therefore be held tomorrow, 4th of December, from 12 to 12:30. Thus, the program on tomorrow would be that we would have first from 10 to 12 o'clock the 7th plenary meeting on cooperation, to be followed from 12 to 12:30 8th plenary meeting on progress reports by the coordinators and introduction of draft resolutions, of course. If the outstanding consultations are completed by tomorrow, we would then aim to hold the final plenary on Friday, 5th of December at 10 o'clock. This would depend on the progress of the remaining consultations, but does the Assembly agree to this proposed change in the schedule of the Assembly? Thank you. I do not see any objections. It is so decided. I thank the interpreters, and the 7th plenary will start, as said, beginning at 10 o'clock tomorrow. And unless there are any other requests for the floor, this meeting is adjourned.